Good evening. I'm Brenda Wortel, legal analyst from the Republic of South Africa, and I've recorded this in support of an interview that was supposed to have gone smoothly, but with the Skype connections being problematic. My response briefly to the questions around the Oscar Pistorius trial. Firstly, I need to make it, crystal clear that I side with those legal professionals, especially Professor Grant, who feel that either dolus directus was sufficiently proved, and secondly, if not dolus directus, then error in objecto, meaning that even though the court found he didn't have the intention to kill River Steenkamp, he did have the intention to, basically kill whoever was behind that toilet door. And I base that essentially on the objective facts of the case. Oscar's distance from the toilet when he shot in there, his own allegation that he screamed out for the robbers to get out of the toilet. That for me is the crux of the matter, because had River Steenkamp been in the toilet and Oscar Pistorius was in the bathroom, given the short space of the length between that passage and the toilet. I mean, this is not an overly fancy house that is large and there's additional space, etc. So if he had actually shouted as loudly as he said he did for the robbers or whoever it was in the toilet, the intruders as he puts them, to come out, then it would have been clear. Riva would have said, I am the person in the toilet, because obviously there's only one toilet on the top floor, and she wouldn't have kept quiet. So I just think that the judge's reasoning, look, it's not even just about the fact that she found Oscar Pistorius guilty on culpable homicide. In law, there is a method to the madness, and I know Aristotle said, law is mind without reason. But there should be method. There should be a method. So I just feel that the manner in which the court analyzed the facts, the rejection of some of the evidence, and obviously those factual issues are not even going to play a part should the state decide to appeal against this decision. But, what I just feel, it's not really about the decision that she reached of finding him not guilty on the charge of culpable of murder, both dolus directus and dolus eventualis, but more how she got to reach that decision and her reasoning. And of course, this is a court of first instance, the court a quo, as they would say, and even though on limited grounds, the state can still basically appeal. What I do condemn in the strongest terms, though, are the unnecessary criticisms against Judge Masipa. The racist comments, the derogatory comments. South Africa is a constitutional democracy, and we really, really come from a very, very sad and horrid past, and there is no place for that. It is the judgment that I am critical of, the reasoning within that judgment, and I just feel that some of the legal principles have been misapplied. On the question of the difference between culpable homicide and dolus eventualis, I think I made it quite clear that with culpable homicide, negligent killing of a human being, we do know that with any crime, there has to be an intent in order for the state to sufficiently prove guilt beyond reasonable doubt. Where the dolus directus, where the example I used, somebody walks in and they fire a shot and kill, or they stab someone else intently, or dolus eventualis, which, by the way, is just one of a few other forms of dolus, where you reconcile yourself with the fact that the death or injury of that person might actually ensue. So that is my take. It's early days. We don't know what is going to happen. As far as the sentencing is concerned, the minimum prescribed culpable homicide, when a firearm is basically used, obviously it's a Schedule 1 offense, but where a firearm is essentially used, then it's 5 years minimum. But still, there's a lot of leeway. There are a lot of instances and situations that can be taken into account. And the other acquittal that really bothered me was the one on the possession of ammunition, because that was clear in violation of the Firearms Control Act of 2000. And again, I feel that the Honorable Judge really misdirected by applying the law in that way and making an example, using an example of someone, an innocent person who walks on the street, picks up a firearm and takes it to a police station, or the case law that she cited where a bank robber who was charged in terms of the doctrine of common purpose flees the scene and is acquitted. Those are totally different. Even though when applying legal principles, when applying the doctrine of precedent for argument's sake, you take into consideration the reason for the decision by the higher court, which is binding, not necessarily the facts, but I think even the facts were incorrectly applied to the case of Oscar Pistorius. On the issue of River Steenkamp's family wanting the truth, unfortunately for them, our courts are not really there to get to the truth, and that's the cardinal difference between what is called moral guilt. That is, some people will always see Oscar Pistorius as a murderer, but our courts are there to ensure that justice is not only done, that it is seen to be done, and basically that legal guilt is proved, and legal guilt is guilt beyond reasonable doubt. On the issue that the case is largely based on circumstantial evidence, this is not the first case that is largely based on circumstantial evidence. Rex versus Blom is the leading authority, cardinal rules of logic, how inferences or inferential reasoning ought to be guided. And just as a matter of interest, I'm currently working on a thesis, but testing whether or not convictions which are largely based on circumstantial evidence, where the courts employ inferential reasoning, do not violate an accused's right to be presumed innocent. So that is my take. We shall see what happens. Obviously, the state cannot appeal if it intends to appeal at all. They cannot appeal until the entire proceedings have been concluded, because appeals shouldn't be conducted in piecemeal fashion. But it will be back to the courts in a few weeks from now, and we'll hear how the sentencing goes. From South Africa, good night.